Okay, so the first chapter is English legal system. Now, what is the legal system? The legal system in any country has two jobs to do. The first job is to make the law, and second job is to implement the law. Now, what is law? Law is basically a formal mechanism of social control. Formal mechanism means that there is a formal authority that have laid down, that have set down some rules and regulations of social control. Those rules are, and regulations are set to enforce the people behavior in a certain way. So that is a law. So a law is basically a rules, regulation, principles that tells the society how to behave, and those rules are enforced on the society. So the legal system of the country, job of the legal system of the country, any country, is to make the law and then to implement the law. There are two types of law: public law and private law. Public law is a law that is concerned with the matter related to public administration. It means that the law that is related to the general public, to every citizen of the country, that law is known as public law. For example, constitution law, the law that constitution creates, parliament creates, it is applicable on every public member. Similarly, criminal law, administration law, criminal law is applicable on all general public of any country. The other type of law is private law. Law that is concerned with relationship between two individuals. The law which is not applicable to the general public, but it's only applicable to two individuals. That is concerned with relationship between two individuals. Like for example, contract law. Now, if I and you had done a contract, and if let's say I breach the contract, I break the contract, then the law will tell us about how to behave just between two of us. The contract law, it's not applicable on general public. It is only applicable to the parties of the contract. So that law is concerned with relationship between two individuals. Tort law, tort law, the word tort basically means civil wrong. Like for example, if someone is walking on a road and you hit him, now that is a civil wrong. So if let's say your neighbor is playing out music loud and it's affecting you, that is a civil wrong. So that is known as tort law. So in tort law, the parties concerned are, the one that is innocent party and the other party that has committed the tort or the civil wrong. Similarly, in employment law, it is concerned with the relationship between employee and employer. So such type of the law are concerned with the relationship or the matter between two individuals. That law is known as private law. Now there are two branches of English law, or two branches of the UK law. Criminal law. Wait a second. Criminal law and civil law. Criminal law relates the conduct which state disapproves. It is form of public law. So criminal law is a type or is a form of public law, and it relates to the conduct which state disapproves. So criminal law tells us those conduct that the government or the state disapproves, the conduct that we should not perform. Similarly, civil law relates to the matter between two individuals. It is form of private law. So again, civil law is a form of private law, and it is concerned between the matter of two individuals. Now let's differentiate them. Now, what is the purpose of the criminal law? Enforcement of the behavior as per state law. The purpose of the criminal law is to enforce certain kinds of the behavior that a government wants people to follow. So that is the purpose of the criminal law. That is why the criminal laws are created. Civil law purpose is to settle dispute between two individuals. If there are disputes, if there are issues between two individuals, civil law helps to resolve those issues. Burden of proof. Burden of proof in the criminal law is on prosecution. Prosecution basically means the state department, the police, the state lawyer. They are the one who have to prove that the other person has done crime. So if a person has done crime, the state has to prove that this person has committed the crime. While in civil law, the burden of the proof is on claimant. Claimant is basically a person who seeks remedy, a person who wants solution. Usually that person is a victim. So he has to prove that wrong is done to him. He is the one who have to prove that something wrong has happened to him. Standard of proof is beyond reasonable doubt. Now in the criminal law, because the consequences are very harsh. Like in criminal law, if your crime is proved, you can go to the jail, you can be sentenced for life, you can be hanged. So because the consequences are so harsh, so the standard of proof should be high. beyond reasonable doubt means that there should not be a single person doubt that this person hasn't committed the crime. So you have to prove, beyond reasonable doubt, you have to prove that this person has done the crime. Prosecution has to prove. While in the civil law, the standard of proof is balance of probabilities. Balance of probabilities means that the court will hear the evidences, presented to in front of the judge by both claimant and defendant. The one party whose evidence will be bit stronger, you know, that party will get benefit of the doubt. So that is balance of probabilities. Like for example, if I tell you in the form of percentage, so let's say one party evidence is like 60%, other party's evidence is like 40%. So if such is the case, 60-40, then the one who has 60% thinks in favor of him, he will get the benefit of the doubt, and he will get the remedy. So in the civil law, the standard of proof is not that much high. It's just balance of probabilities. Object. Object basically means the reason or what we want from the criminal law. To regulate, the purpose and object are kind of same. Object is to regulate society by threat of punishment. The object of criminal law is to regulate the behavior of the people by threatening them that if you will commit crime, we will punish you. The object of criminal law is not that we want to punish the people. No, the object is that we want to regulate the behavior of the people by threatening them that if you will do something wrong, we will punish you. While the object of the private law is providing compensation to restore the claimant position. Civil law is to providing compensation to restore claimant position. So basically, if something is wrong with one party, so the object will be that give him some compensation so that he can get back to his original position. The result, if found guilty, accused will be imprisoned, fined. If innocent, he will be acquitted. Acquitted means he will be released. So if crime is proved, then he will be imprisoned, he can go to jail, he can be fined, plus he can go to jail as well as fined. And if he is proved innocent, then he will be acquitted, he will be released. While in case of civil law, court will order defendant to pay damages or some other remedy. Court will order defendant, the one party who was defending himself and could not, he have to pay damages or some other remedy. Damages basically mean monetary compensation, and some other remedy, when we will go on with the syllabus, we will talk about that what are the other solutions that you can get. Clear? Is this clear?
Yeah, perfect. Yeah,
Okay,
perfect.
okay. Then English court system. Now, any court system in any country, the duty of the court system is to provide the justice in time. There are two things: to provide the justice, and the second thing is provide the justice on the time. So if a court system needs to be efficient, they have to provide the justice to the people on time. And the cost of the court system should not be that much high. So if a court system of a country want to be an efficient one, it should provide the justice on time, and it should be cost effective. Now in UK, the court system is structured. The court system is divided into two different types of courts: civil courts and criminal courts. Civil courts, as the name is suggesting, they are related to dealing with the civil matters. Now, what are different types of civil courts? The smallest civil court in the UK is county court. County court is first instance small fast track civil claim. In county court, first instance small fast track civil claims of contract, tort, landlord and tenant probates are heard. So what do you mean by first instance small and fast track civil claims? Small claims are the claims that are of less than 10,000 pounds. Like for example, if you and I had a contract and I broke the contract, you put a claim of 7,000 pounds on me that he has broke the contract and he have to pay me 7,000 pound damages. So the claim, because it is less than 10,000 pound, it is a small claim. Fast track claim is any claim that is in between 10,000 pounds to 25,000 pounds. So first instance small and fast track civil claims of contract, tort, landlord and tenant, or probate. Probate basically means a will. When someone dies, his will is to distribute his assets, and how to deal with those such matters are heard in county court first instance cases, presided by district and circuit judges. The case is heard by either the district judges or circuit judges. Like in other countries, there is provinces. In UK, there is circuit. So this is the jurisdiction. This is the authority of the county court. Then the next court is magistrate court. Now, magistrate court has a very limited civil jurisdiction, civil authority, because magistrate court deals with the most method that are of the criminal origins. But the civil things that the magistrate court deals with is the family law, any matter regarding the family, like matrimonial or divorce cases, custody cases, council tax and business rates enforcement. In UK, you have to pay the council tax and the businesses have to pay the business rates. So if someone does not pay them, then the claim is put in magistrate court, and it is the job of magistrate court to recover those things from the people, relevant people, presided by district judges or lay magistrate. The case in the magistrate court is heard by district judge or lay magistrate. Lay magistrate can be any person who voluntarily hears the case, and it is usually the person in that area who is, like kind of famous in that area, and people go to that person to deal with the different things. So such person can, voluntarily act as a lay magistrate and hear the cases. The second number court is High Court. High Court here's the first instance multi-track civil claims. Multi-track civil claims are the claims that amount is more than 25, whose amount is more than 25,000 pound. So they are kind of a significant cases because the damages involved are of the higher amount. Plus, High Court also hear appeals from lower courts. So, if someone is not satisfied with the decision of the county court and magistrate court, they can make an appeal to the High Court, and High Court will hear those appeals as well. It supervises and regulates conduct of lower courts as well. The High Court also supervises the lower court and their conduct, in what manner they should be run. It has further three divisions. High Court has further three divisions: King's Bench Division, Family Division, and Chancery Division. Now, King's Bench Division, it deals with the contract and tort matters. So if there is let's say first instance multi-track civil claim that is regarding the contract and tort, it will be heard in the King's Bench Division of High Court. It also hears appeal from lower court regarding the same cases. Like for example, if there is an appeal regarding the contract and tort, it also hear appeals. Now appeal is heard by further appeal division of the King's Bench Division. Every division of High Court has a further appeal division which hears the appeal regarding the relevant matters of that division. While the King's Bench Division also can hear some criminal appeals as well. Then family divisions, it deals with the matrimonial and family law cases and hear appeals regarding these matters. So again, the jurisdiction of the family division is that they deals with the matrimonial cases, family law cases, custody of the child cases, divorce cases, which are of big cases, significant cases. These are heard by the family division. Plus, any appeal regarding these matters is heard by the appeal division of the family division. Then the chancery divisions, it deals with the land law, company law, partnership law, and also here appeal from the county court regarding these matters, and the appeal is heard by the appeal division of the chancery division. So each division of the High Court has further appeal division which hears the appeal from the lower courts. Clear?
Yep.
Then comes the Court of Appeal. Court of Appeal hears appeal from civil matters from High Court and County Court. So Court of Appeal also hears the appeal from High Court, and plus it hears appeals from the county court as well. Now, why do the Court of Appeal hears the appeal from the county court? Now, this is very interesting point that some appeals are made on point of law and some appeals are made on the factual basis. Now, I have written down here that the green line, it represents point of law appeal, while the red line, it represents the factual basis appeal. Now, you can clearly see a green line that is going from county court to Court of Appeal. So it means that if an appeal is made on point of law, then you can directly make an appeal to the Court of Appeal from county court by skipping High Court. This is known as leapfrog procedure, that you are leaping one court. That is known as leapfrog procedure. Now, what does the word point of law means? Point of law means that if you feel that the decision made by the judge, the law that was used to make the decision was not right, right law was not implemented while making the decision, then this is known as point of law. So if you feel that the decision made by the judge, that the law on the basis of which judge made the decision, that was not right, the right law was not implemented in making the decision, then you can make an appeal directly to the Court of Appeal. While if it is on factual basis, then you can make the appeal on the High Court first, from county court, and then high court decision can be appealed in the appeal of the high court decision can be made in court of appeal. Okay, so if the green line represents that you are jumping one court, that is known as leapfrog procedure. Now the most highest court of the UK is Supreme Court. Before before the Brexit, when the UK was part of the European Union, the European Union Court was, of was of supreme was the supreme authority that was highest authority that has most influence over all the courts in the European Union. But because UK is no longer part of European Union, Supreme Court is the highest court. Now, the job of Supreme Court is to hear the appeal from either Court of Appeal or from High Court. So, if the appeal is made from the Court of Appeal, then the appeal will be made on the basis of the facts of the case, while from High Court you can directly make appeal to the Supreme Court on the point of law. On the point of facts basically means that if you feel that the facts of case were not completely presented to the judge, or judge didn't hear the case in a right manner, then you can make an appeal on the points of the facts, on the material facts, on the factual basis. But if you feel that the law applied was not relevant, or the wrong law was implemented while making your decision, then that is known as appeal on the point of law, and for that you can leapfrog, you can skip a court. Clear?
Yep.
Then comes the criminal courts. The lowest criminal court is magistrate court. Now, I told you that magistrate court has mainly criminal jurisdiction. Now, magistrate court deals with summary offenses. Summary offenses means minor offenses, the offenses who like minor crimes, less serious crimes are known as summary offenses. Like, drinking, careless driving, etc. These are types of summary offenses. They are dealt by the magistrate court. Now, because they are minor offenses, when these offenses are presented in front of the magistrate court judge, he can clearly make the decision. Like, for example, if someone is over speeding, then the speed camera will caught him that he was over speeding, so the judge will just give him the penalty. That's it. Similarly, if someone was uh, drinking, he was intoxicated while driving, then then simply we can have its blood test, and in blood test it will be prove that that person was intoxicated or not. So the judge will make the decision. So these are just summary offenses, small, less serious crimes that can be dealt with quickly. Impose imprisonment of up to 6 months and unlimited fines. The magistrate court judge can impose the imprisonment of up to 6 months in respect of the summary offenses, and unlimited fines. Unlimited fines mean that depending upon the case, fine can be anything. Presided by the district judge or lay magistrate. Lay magistrate and district judge, they hear the cases of the magistrate. Then comes the Crown Court. It deals with indictable offenses. Indictable offenses means major offenses like murder, rape, and robbery, something like drug cases. All these are indictable offenses. Case proceeding is heard and punishment is imposed. Now, because they are kind of major offenses, so there is a proper trial by jury. You will be presented in the front of the jury. You have to give the evidences. The prosecution will give their evidences. So a proper case hearing will be done, and then the final decision is made. So there's a proper trial by jury in the Crown Court. Crown Court also hear appeals from the magistrate court on question of facts. So if you are not satisfied with the decision of the judge of the magistrate court, you can make appeal on the Crown Court on the factual basis. Presided by circuit judges usually. The circuit judges preside the Crown Court. Okay. Now here you can clearly see that a green line is drawn from magistrate court to the appeal division of King's Bench Division. Now when I was telling you about the appeal division of the King's Bench Division, it was mentioned that it hears some criminal cases as well. So these are the one that can be heard by the appeal division of the King's Bench Division. The appeal on point of law. On point of law means that you feel that the law apply, it's not right law that was applied in making your decision. Like, for example, if you have kept some offensive weapons like gun in your house, and the police caught you that having gun or weapons, and you did not have any license, and they charge you under the terrorism law. Now, yes, you had gun with you, you possessed the gun, you did not have the license, but the terrorism law it does not apply on you, right? It's the wrong law that is applied. So this is how appeal on the point of law works. When you feel that the law applied is not the right one, then you can skip a court and make appeal directly to a higher court. So in that case, the magistrate court can made appeal on the in the King's Bench Division Appeal Division. Similarly, Crown Court can also make the appeal on the point of law. King's Bench Division Appeal Division here appeals on the point of law from Magistrate Court and Crown Court, presided by three High Court judges. Three High Court judges preside the Appeal Division of King's Bench Division. After Crown Courts come the Court of Appeal. The Court of Appeal hears the appeal from the lower court, that is Crown Court, on the question of facts. And then comes the Supreme Court, that is the most superior court of the UK. It hears the appeal from the Court of Appeal on the factual basis. And it can also hear the appeal from the Appeal Division of the King's Bench Division on point of law. Now, there is another type of offense that is written here, that is triable either way. Triable either way means that this offense can be either tried in magistrate court or crown court. Like for example, like offenses like theft, drugs, violence. Like for example, there is a theft of a huge amount. Then if the theft is of huge amount and proper proceeding is needed, then that case will be heard in crown court. If the theft is of small amount, the case can be heard in magistrate court. So when the case will be brought forward to the magistrate court judge, he will decide whether that case should be tried in magistrate court or crown court. So the offenses that are triable either way, they can be either heard by magistrate court, or they can either be heard by the crown court, and the judge of the magistrate court will decide where the proceeding should be carried on. So these are the criminal courts. Clear?
Yeah.
Okay. Some other courts are European Court of Human Rights. European Court of Human Rights is the final appeal court regarding matter related to the human rights. Cases must have been exhausted in Supreme Court first. So if anyone is not satisfied with the decision of the Supreme Court regarding the human rights matter, then the appeal on that decision can be made to the European Court of Human Rights, only if the matter is regarding the human rights. Cases must have been exhausted in Supreme Court first. It means that the case must have been heard by the Supreme Court first, and then the appeal can be made. It's not like that you can make directly appeal in the European Court of Human Rights without the case being heard in the Supreme Court. No, the first case should be heard in Supreme Court, the decision should be made, and then that decision should be appealed in the European Court of Human Rights. Then there are another type of court, that is Judicial Committee of Privy Council. It is basically a committee made in the courts. Highest court of appeal for Commonwealth countries like Crown dependencies and UK overseas territories. Now, Commonwealth countries are those countries which are Crown dependencies. Like, for example, Australia is a Commonwealth country, New Zealand, there are certain African countries, there are some islands on West Indies, those are Crown dependencies. So these countries are known as Commonwealth countries. Now, the highest court of appeal for the Commonwealth country is the Judicial Committee of Privy Council. Like, for example, if there is a case in Australia and the Supreme Court of Australia have gave the decision, and if you are not happy with it, happy with that decision, you can make an appeal in Judicial Committee of Privy Council. Hearing of both civil and criminal cases are done here. Proceedings takes place in Supreme Court. The proceedings of the appeal uh, of the Commonwealth countries, the proceedings took place in the Supreme Court of the UK. So Judicial Committee of Privy Council is the, you can say, highest court of appeal for Commonwealth countries, Crown dependencies, or UK overseas territories. Clear?
Yeah.
Now, then comes the tribunal. We just talk about the court. Now, tribunal is an alternative to using the court system. Like, if I could explain you the tribunal in easy word, like for example, in our family, there are some elder peoples. If something is, if there are some disputes going on family, we go to those elder peoples and they make the decision, right? So the tribunal is kind of like same thing. Like for example, if we in the law exam, we are just going to talk about the employment tribunals. Now, let's say there was some dispute between employer and employee of the company. So employee, instead of going to the court, can go to the tribunal. The employment tribunals are established in every organization. So employees, whether instead of going to the court, and you have to have a proper formal proceedings, and it can be a costly procedure, lengthy procedure. So instead of going there, you can settle the matter in the employment tribunals. So employment tribunals are there in an organization. whose job is to hear the dispute between employee and employer and solve those disputes. Employment tribunal composed of one judge, two expert lay people representing both sides. In employment tribunal, there will be one judge who will, who will have a very great knowledge of the employment laws and regulations. Two expert lay people. Lay people means two expert neutrals who are representing both sides, employer side and employee side. Okay, so they make a decision. Appeal on decision of the employment tribunal can be made to EAT on point of law. If you are not happy with the decision of an employment tribunal, you can make the appeal to employment appeal tribunal, and this appeal is heard in the court of appeal. Okay, the appeal from the employment tribunal is heard on the court of appeal on point of law. So this is tribunals. Now, some differences between court and tribunals are expertise. In court, the specialists do not hear the cases. If, let's say, there's a matter regarding employer and employee, and there's a proper employment act that is in place regarding such matters, now the judge that will hear your case, he will not be the expert of the employment matters. He can be any layperson, right? He cannot be any expert of such kind of matters. So in court, the specialists do not hear the cases, while in tribunal, the cases are heard by the specialist. Court is a slower process, while the tribunal is the quicker process. You can get the decision quickly. Cost of the court is expensive. You have to hire the lawyers, and it's an expensive process, while the tribunal, it is a cheaper process. The proceedings of the court are strict and harsh. There are proper formal proceedings. You have to go to different hearings, and there's a proper formal procedure, strict rules regarding the evidence, pleading, procedure. While the tribunal is not that much formal, it is less formal, and it is less intimidating. Decisions. Decisions made by the court are bound by the doctrine of judicial precedent. So consistent decision making. Doctrine of judicial precedent means previous judge decisions. So court, when they are going to make the decision, they can take help from the judge, from the decision of the previous judge if the matter was same. Okay, let's say for example in 2015 there was a matter that was heard by the judge and judge gave the decision. Now in 2024, same kind of matter came again, same kind of the case came again, then you can take help from that judge decision, the previous judge decision, to make the decision of this case. So the courts are bound by doctrine of judicial precedent, so the decision making is consistent. While in tribunals, you are not bound by any judicial precedent, so the decision making can be different. Inconsistent means for every case the decision can be different, while for the court the decision can be kind of same. So that is the difference between court and tribunal. Any question you want to ask?
Yes, sir. Please.
Okay, now comes an important area: sources of law. From where was the UK law derived? Where did the UK law came from? So the law that is applicable in England and Wales is derived from two sources: case law and legislation. European Union law was also there before the Brexit, but now after Brexit, the European Union law is no longer considered. So the case law and legislation. So case law is a traditional source of the law, the old source of the law that is coming through the system of the UK, while legislation is a modern source of the law that is created by the parliament, that is known as legislation. Now let's understand these two sources in detail. So first comes the case law. Case law is the traditional source of the law, and it is further divided, it is subdivided into two things: common law and equity. Now, what is common law? Now, in the UK, like for example, round about 1000 years ago, following the Norman conquest, there were people who were known as group of people who were known as Norman. After their conquest of the UK, the law of the UK was known as common law. Now, how was common law derived? How did the judges create the law? Now, judges would travel around the country, and judges will hear different type of the cases. And after, hearing those cases, the judges will make the decision. And on basis of those decision, the judge makes the law. So that was how the common law was derived. The common law was developed from the local customs. The law, the rules and regulations are developed from the local customs culture of that particular region. Like for example, if there's an Islamic country, the Sharia law is, kind of implemented there. The law that has came from the Sharia, from the Quran and Sunnah. So similarly, the law are developed from the local customs, culture, religion of that specific region of the people. So this is how the common law was derived. So the judges would travel around the country, around the UK, and they will heard the different type of the cases, and accordingly they will make the decisions. So in this way, the law was derived. It introduced the system of the precedent. Precedent means the decision making of the judge. Okay, previous decision making. Now the system of precedent is the same, that if the facts of the cases are the same, then you can use the previous judge decision in making the decision of the latter case. That is what system of precedent means. Only remedy is damages. According to the common law, only solution was financial compensation. Only solution was financial compensation. And the common law was considered to be rigid and inflexible. Why it was considered rigid and inflexible? Now, it means rigid and inflexibility means that the law itself was harsh. The reason is because, uh, the common law, it can be kind of like illogical. Why? Because the law that was created, like for example 809 years 900 years ago, you did not know in what context, what was the situation in which the law was made. Maybe the judge was favoring one side, because of his relation with that side. So that law can be harsh, right? Because you don't know that in which context, in which situation the judge make the decision. And despite this, you still have to follow the decision on the latter cases. So that is why the common law was considered rigid and inflexible. Clear? Common law. Any question you want to ask about common law? Okay. Now, then after the common law, the equity system was introduced in UK. Okay, equity system was introduced like 200 to 300 years later after the common law, and it introduced the fairness in the law. The word equity in law means fairness. How can one get an equity? Equity was developed as a petition by a party who felt common law was unjust. Petition means a request for judicial action, a letter of
So,
formal request.
so, so
Yes.
now common law no longer using, or is it like both used still
No, it's adapted.
adapted to
Yes.
equity?
The law is still there, but the equity has
Okay,
preference. Equity has
okay,
preference. Equity, if there is a clash between common law and equity, the equity will also prevail. You will follow the equity. Okay.
okay,
Now,
okay,
how could one get an equity? Like for example, if a decision was made according to the common law and the party was not happy, then he will put up a letter, a formal request to the king of the UK that, I am not happy with the decision of the judge. So the king of the UK, when he will receive the judicial action, then he will allow your case to be heard again. Okay, so this is how you could get an equity. So equity is granted to that person who felt that common law was unjust. Now because the case hearing was done again, and again the facts would be presented, so the decision making will be according to that scenario, right? You don't have to go to the precedent system now. So that is why the equity was considered flexible than the common law. It introduced new remedies such as injunction and specific performance. Now, according to the common law, the monetary compensation was the only solution. That's it. But in equity, you can get other solution as well, like injunction and specific performance. Now, what does this mean? First, I will give you an example of specific performance. Like, for example, I gave you an example in the last class as well, that let's say there is a very famous comedian, and he had made a contract with a person who is running a theater that he will perform uh, on the weekend, on his theater, in his theater. Now, the contract is done, the agreement is made. Now, what if at the last time the comedian, he withdraws from the contract? He says that I will not be coming to your theater for performing. Now he has done the contract. Now he has break the contract. So if it was common law, what was the solution? Damages. The comedian, because he had broke the law, broke the contract, then he will just pay the monetary compensation to the one who is running the theater, and that's it. But what does the equity say? Equity says that, the person who is running the theater, who has arranged the show, who has sold the tickets to the audience, and the audience are really excited, enthusiastic that, on Sunday that famous comedian will perform. Now, if that famous comedian will not come, it will affect the reputation of the person running the theater badly. So badly that in future, if we arrange some another show, maybe the people, the general public, they will not come to his show, right? Why? Because his reputation was badly hurt by the by the comedian who break the contract, right? So just monetary compensation was not the solution here. So what could be the solution? Judge will say to the comedian that you will do specific performance. Specific performance means you have to perform the task. You have to perform on his show. Monetary compensation is not the solution. You have to perform on that person's show because his reputation is at stake. So this is a new remedy, specific performance. Clear? Similarly, injunction. Injunction means preventing someone to do something. Like, for example, there's a case in your book in which a very famous actor, I forgot his name, he contracted with the Warner Bros. Production company, and the contract that Warner Bros. Made with him was that he could not do the any character that he's doing with them. He had signed that actor had signed a movie with the Warner Bros. Production, and in that movie he was playing a certain fictional character. Now, the Warner Bros. In the contract clearly mentioned that the fictional character that you are playing with us, you cannot play that character with some any production team, or you cannot sign any film in which your role is kind of similar. Okay, but that actor, he broke the agreement, and he signed a film in which the character was kind of like same of what he signed with the Warner Bros. Now here, the thing is, if it was for the common law, the actor, he breached the contract, he would just have paid the monetary compensation to the Warner Bros. Production house. But that was not it. The judge said that, that because the people, the general public, they had a perception of a certain, fictional character in a movie. So if that same character will be played by that person in some other movie, so the reputation, right? Reputation, or the Warner Bros. Production, they could get in very much losses, right? Because that perception will be hurt, because the perception in the mind of the general public is created by an actor who is playing a certain role, right? And if he will play that same similar kind of role with any other film, then that perception can be broken, and it can affect the Warner Bros. Production profits, right? So in that case, the court ordered injunction. The court prevented that actor that you could not perform the similar kind of role with any other production house. Okay, so that was injunction. The court said you can perform any other role that you want, but not that similar kind of the role that you are already doing with the Warner Bros. Production. So that is a fair decision, right? So this is how the equity works. Clear? Will not be granted if there was undue delay, petitioner acted unfairly, and there is no mutuality. In these situations, the equity would not be granted to you. When there was undue delay, something bad happened to you today, and you are going to the court after 2 years, 3 years. So there's an undue delay. Equity will not be granted. Petitioner acted unfairly. You yourself acted unfairly. Like, for example, if someone broke your car, so in return, you also broke his car. So you also acted unfairly. Now you cannot go to the court and say that, grant me the equity. Why? Because you had acted unfairly yourself. If someone had broke your car, just go to the court and file the case against him. That's it. You will get your remedies. So if you yourself has acted unfairly, then you will not get equity. And there is no mutuality. Mutuality means that both parties cannot bring forward the case. Like, for example, one party is in UK and other party is in Europe. Now the party who's in UK cannot, file a judicial action letter for the person that is not currently in the UK premises. He's in Europe, right? So the both parties cannot bring forward the case right now. There is no mutuality. So in that situation, equity is not granted. Any question you want to ask, you can ask.
Yeah.
Okay. Now let's go into the detail of doctrine of judicial precedent. I just told you that doctrine of judicial precedent means that you have to follow the previous judge decisions. Okay. Now, do we have to follow all of the previous decision of the judge? No, no. We have to consider some factors while deciding whether or not we should follow the decision or not. Okay. So it's not that you have to follow the decision of the every judge in the past. You have to consider some factors, and then you will see, that whether that decision should be followed or not. Now, what is doctrine of judicial precedent? System adopted by judge of following decision in previous cases is known as doctrine of judicial precedent. We have already talked about that. Some precedents, the word precedent means decisions, judicial means judges. Some precedents are binding, some decisions are binding. Binding means they are mandatory to be followed by the judge in future. Okay, in the future cases, some decisions are binding. Binding means they must be followed. And some decisions are persuasive. Persuasive means they can be followed. It's up to the judge. If he want to follow that decision, well and good. But if he do not want to follow, he will not follow, right? So that is known as persuasive. Clear? Now, how can we identify whether the precedent is binding or persuasive? There are three factors you need to consider. The first one is hierarchy of courts. You will see that which court had given that decision. Okay, you will see that which court judge has made the decision. Now, if the Supreme Court judge has made any decision, it binds all lower courts but not itself. Now, what does this mean? The decision made by the judge of the Supreme Court is binding on all of the judges of the lower courts, but not on the judges of the Supreme Court. Is this point clear?
That's mean like the Supreme Court can, they don't have to bound by their
Yeah, their own
decision,
decision. Yes, their own decision.
own
Yes.
decision.
But
So they can change.
yes, they can. The decision in the future, it's not necessary for them to follow the previous decision of their
Okay.
own judge.
Uh, it's not must.
Yeah, it's not must. It's not mandatory. But for the lower courts, the decision of the Supreme Court judge is binding on them.
Okay.
Now, if Court of Appeal judge make a decision, then it binds all lower courts and itself in civil cases. So the decision made by the Court of Appeal judge is binding on all of the judges of the lower courts, and civil Court of Appeal also bind itself in civil cases only. So it means in the criminal cases, it's not necessary, it's not mandatory to follow the previous judge decision of the Court of Appeal judge. Okay, clear? While the High Court is not bound by its own decision, but strong persuasive authority. It means that the decision made by the judge of High Court, it is persuasive on the lower court judges, county court, magistrate court. They are not, it's not mandatory for them to follow, but they can take help from that. Persuasive basically means it's not mandatory to follow that decision, but you can kind of take help from that decision. Okay, so High Court is a strong persuasive authority. Clear? So the first factor that you need to look for whether to consider the decision was binding or not is hierarchy of the courts. Now, the second one, ratio descendi and obiter dicta. Now, the decision, that is made by the judge, the decision is of like 10 to 12, lines, and that's a very big decision. Now, the decision that is made by the judge, the wordings of that decision are divided into two things, ratio descendi and obiter dicta. Ratio descendi means legal reason behind the decision, the law which was applied, the decision that was made by the judge, the statement, the statement that was given by the judge when he made a decision. Now, in that statement, the reason behind which he made the decision, or the law that he used to make that decision, that law, that legal reason is binding on the future judges. Okay, that legal reason is binding on the future judges. And obiter dicta means statement made by the judge that may help to understand situation. Like for example, when the judge was giving the decision, he just mentioned some other hypothetical situations, just other general statements to let people understand the situation. Now, those things that are said by the judge, they are known as obiter dicta, and they are persuasive. The future judge can take help from those things, but it's not necessary to follow those things. while the legal reason because of which the judge gave the decision, that legal reason is the binding on the future judges. Okay, is this point clear? Okay, like for example, if the judge of let's link these two first two things. If the Supreme Court judge gave the decision and then the ratio descendi of that decision, the legal reason behind that decision is binding on the all lower courts. Okay, not the obiter dicta one. Obiter dicta one will be considered as the persuasive thing. Okay, so in this way you can interlink these two things. Clear? And the last factor is material facts of the cases. In order for precedent to be binding, material facts of two cases must be same. If they are significantly different, precedent will be persuasive. If you want to follow the previous judge decision, then the two cases should also be kind of like same, right? If they are significantly different, then the previous judge decision is persuasive, it's not binding. Like for example, 10 years ago, a person murdered someone. Okay, there was a 36 years old man. He murdered someone. Now he killed someone. Now today, let's say in 2024, there was a 7-year-old boy. He also killed someone. So will that the decision made by the judge at that time be precedent on the case of this decision? No, right? Because the facts are different, right? So if the facts of the two cases are different, then the previous judge decision is merely a persuasive. It is not binding. Okay, clear? Now the thing is, now this thing is very subjective, that whether material facts of the cases are same, or whether they are different. Now this is a very subjective thing, right? It's very difficult to assess, but you have to assess that in order to consider, whether the previous judge decision should be followed or not. Okay, clear? A precedent is not binding if it is overruled. First, let's understand these three terminologies. Overruling, reversing, and distinguishing. Now, what does overruling means? When a superior court overturned decision of lower court in different case. Very important point. Superior court judge overturns the decision of the lower court judge in different case. Now, what does this mean? Like, I will give you an example. For example, there was a certain case in 2000, and the high court judge made a decision on that case. Now, in 2020, there was another case that was brought forward. But while making the decision of that case, the previous judge decision was taken as the binding. The decision made by the judge in year 2000. The case was, different. The facts were same, but the case was different. It was not the same case. Now, in 2020, when that high court judge decision was followed by the judicial precedent was implemented, and the decision of the 2000 the high court judge who made the decision in 2000, that was followed later on in 2020. Now that decision was overturned when appeal was made in a higher court. Okay, when an appeal was made in higher court, like for example Supreme Court or Court of Appeal. So this is known as overruling, when a superior court overturned the decision of the lower court in different case. Have you got this point?
It means like the overall decision change.
Yeah, the case were different, but the judicial precedent was same. So that judicial precedent was overturned by the higher court judge. Okay, like for example, in year 2000, high court judge gave a decision. Now in year 2020, there was another case, and the facts of the cases were kind of similar to the ones in 2000. Now that high court judge in 2020 took help from the decision of the 2000 high court judge, but that decision was reversed. That decision was overturned by the Supreme Court in 2020. The Supreme Court has overturned the decision of the lower court judge. So that is overruling in the different case. Okay, but if the decision is overturned in same case, it is known as reversing. Like for example, there was a decision made by the high court judge, and that decision was the appeal was made uh, in the Court of Appeal or Supreme Court, and Court of Appeal or Supreme Court overturned the decision. So that is reversing. So reversing is done in the appeal scenario. Okay. So that is the difference between overruling and reversing. Clear? Distinguishing, where judge don't follow precedent because material facts of the two cases are different. So we already talked about that, that if the material facts of the two cases are different, then the decision is not a precedent. The terminology used for this is distinguishing. Okay. A precedent is not binding if it is overruled by higher court. We just talk about that. If it is overruled by statute, very important, the law that is created by the parliament, it has more importance than this law, okay, than the judicial precedent. The law created by the parliament, that is known as statute, we will talk about that shortly, it has more significance, more importance than the precedent. Okay. It was made without proper care. If the decision made by the judge in, let's say, in the past was made without proper care, the judge did not make decision, the judge make the decision because, let's say, he was misinformed, or let's say the facts were not presented in the right way. So without proper care, a decision was made in the past. Now that past decision will not be binding if it is, or if it was made without proper care. Okay. And if it can be distinguished from the earlier cases, if there's a distinguishing, then obviously the precedent is not binding. Any question you want to ask? Okay. Now, what is the advantages of judicial precedent? Consistency. Now, the consistency, well, obviously, because you are following the decisions of the previous judge, so you can predict the result as well, right, in advance. Like, that the judge will follow the decision of the previous judge, and that decision is already available. So you can predict the result of the case. So that the decision making will be consistent. Consistent means they will be kind of same. Okay. Why? Because you are following the judicial precedent. Clear? Flexibility. The judicial precedents can also be flexible. Like, for example, the in we just talk about the equity stuff, that the previous cases, when the petition is filed, then in equity the new decision is made, and the old decision is now adapted into the new decision. Similarly, in the judicial precedents, because there are multiple cases going on, so the later judge can adapt the decision of the previous judge, right? That decision can be adapted. So that's why it is flexible. You can adapt the decision to reflect the changes in society. Like, for example, if a judge gave a decision in 1920, so when in 1990 a similar kind of the case come, now the new judge can take help from the decision of the previous judge, but he can adapt that to reflect the society changes at that time. Similarly, you can adapt the later cases as well. So it's a flexible system. Okay. Clarity. The law is clear, because the fun thing is, the previous judges decisions are there, so you have a clarity about the case. The other thing is that have to just follow ratio descendi. Ratio descendi means the legal principle because of which the decision was given. So you are following the law itself, so it means there's a clarity in the system. Practical. Practical means that the decision arise from actual events. The actual cases happened, and then the decision was made. So it's a practical system. It's not that something didn't happen and you created a law in advance. It's a practical system because that case was, that case actually happened, and it was taken to the judge, and then judge gave the decision. And the last is, it's time saving. It's time saving because obviously you are following the decision of the previous judge. So, you can go through the case quickly because you already have, you can take the help from the previous decision. Okay. Clear? Any question you want to ask, you can ask.
Okay.
Okay. Now, disadvantages of judicial precedents. What are the disadvantages? The biggest disadvantage is complexity. There are, thousand and thousand and thousand and thousand of the cases that are recorded. So it's very hard for the judge to, to see which decision that I should follow, right? Because there are multiple cases, thousand of the cases. So it's hard, it's complex. It can become rigid. Wrong decision of the past may prevail. If the law is not adapted, it's not, if it is not adapted according to the changes in society, the wrong decisions can be carried forward in the future, right? Let's say a judge made a decision back in like 200 years ago, the same decision, and that decision was not made right by the judge, but the same decision can be followed, right? If uh, if that decision was not adopted. So it can become rigid. Okay, it's a can situation. It may be rigid. Reactive, not proactive. Reactive means that you are reacting to past rather than anticipating future. Like for example, a case happened and then you make a decision. Proactive approach means that if you are saying that this issue can happen, create a law in advance. That is proactive. That if the issue is arising, create a law in advance. Reactive means that something happened and then you reacted to that. Okay. And the last thing is distinguishing can be a subjective procedure. It is hard to distinguish. It is hard to identify. It is hard to identify whether the material facts of the two cases are different. So it can be a very subjective procedure. It is a very dependent procedure. Depends upon the nature of the person, or the one who the judge, that how does he consider the fact of the cases, whether he consider them to be identical, to be interlinked, or whether they are significantly different. So it's subjective on the judge. So this is the disadvantage of judicial precedent. Any question?
Yeah, good.
Then comes the legislation. So the traditional sources of the law was the common law. The traditional sources of the law was basically case law, and the case law was subdivided into the common law and equity. Then we talked about the judicial precedent that the common law follows. Now we are going to talk about the modern source of law, that is known as legislation. Legislation is a law made by parliament. It is also known as statute or act. So a law that is made by parliament, it is known as legislation. Statute. Legislation is of three types. New legislation. New legislation means a law that is made on a new issue. Codifying legislation. It converts case law into statute. It's very important that, like for example, there was a certain decision that was made by a judge, and the parliament wants to make the law regarding that decision. The same decision, they want to make the law. They want to make that decision a law. So they can convert that into statute. So that is known as codifying legislation. Okay. And consolidated legislation means it merges small statute relating to the same matters into single legislation. So let's say if you are creating the laws regarding the employment, so you will just merge all these law in one book, like, and you will name that book as Employment Act. In Employment Act, all of the laws are regarding the employment. So that is consolidated legislation. We will talk about the Companies Act. In Companies Act, all the laws regarding the company are mentioned in one book. So that is an act. So you are merging all the small laws that are relating to the same matter in a one single legislation, in a one single book. That is known as act, and this type of legislation is known as consolidated legislation. Clear? Legislation falls in two categories: acts of parliament and delegated legislation. Acts of parliament is known as primary legislation, and delegated legislation is known as secondary legislation. Now, what is acts of parliament? Now, acts of parliament means that the law is created by the parliamentarians. Now, in UK, there are three houses: Houses of Common, Houses of Lord, and Monarch. So these are three different departments that parliament comprises of. So parliament consists of House of Commons, House of Lords, and Monarch. Now in Pakistan, House of Common is known as National Assembly, while House of Lord is known as Senate. I don't know what is the name in the Sri Lanka. I think it's the same, like National Assembly or
That's
Senate.
same.
National Assembly and
Yeah,
Senate, right?
yeah,
So
that's what I mean.
yes. Now, how is a law created? Now let's discuss that how a parliament creates a law. So first thing is a bill. A bill is passed regarding an issue. In order to become act, it passes through following situation. So the first thing is that an issue is raised in a general public. The first thing is that an issue is raised in a general public, and a bill is then made and passed regarding that issue. Like for example, there's an issue going on in the society that child labor is becoming common. The issue is that people are recruiting, hiring the childrens as their labor, underage children like 10 years old, 11 years old. Now this is an issue. Now when this issue will become public, when more people will talk about that, then a bill will be passed regarding that issue, that that this is a problem that is going on into the society. So you have created a bill, and the bill is passed regarding an issue. Now that bill will be presented in the parliament, and then it will go through the different procedures to become an law or to become an act. Okay. Now what are the different stages? Now let's see. First reading. First reading is name of the bill and proposer is read out. In first reading in the parliament, the person who presented the bill, and the name of the bill, like for example, child protection bill, and who proposed that is read out. Then in second reading, detailed debate on bill is made and then voted upon. In second reading in the House of Commons and House of Lords, the steps that we are talking about, all these steps happen twice. First in House of Commons and then House of Lords. Okay, so in both houses, these stages are repeated. So in second reading, the debate on the bill is made. The parliamentarians, they make that the debate on the bill. That they make a debate on the issue, and then a voting is done. Then comes the committee stage. Like for example, if the more voting is in the favor of the bill, then you will go to the committee stage. A committee of legal expert and MPs means member of parliaments, consider wording of the bill and ensure they are professional. Now you know that in law, every word that you use in creating a law, it has importance. So the law should be created in a professional manner, right? So that is why a committee is formed in which the legal experts and member of the parliamentarians are there, and they consider the wording of the bill, and they amend the bill, and they change the bill, and they ensure that that the law that we are going to create regarding the bill, it should be in a professional manner. Okay, because in bill a very detailed things are mentioned, but to create a law, you have to summarize that, right? The professional wording should be used. So all this stuff is done in the committee stage. Committee stage can last several months. Like for example, it depends upon the nature of the bill. So let's say 3 months, 4 months, 5 months. So it is a time taking process. Then comes the report stage. Amended bill is reported back to the parliament for approval. The amended bill, the bill that is amended, it is reported back to the parliament, and then the third reading is done, in which the bill is read for the last time. The amended bill is read for the last time. At the end of the process in both houses, bills must receive royal assent. Royal assent means signature by the king. When these stages are carried in both houses, houses of common and lords, then this bill will go to the king of the UK, and he will sign the bill, and now that bill is converted into the law. So in this way, a law is created. Any question you want to ask?
Okay.
Okay. You're not feeling sleepy, right?
No, no.
Okay. Doctrine of sovereignty of parliament. Now, a very important concept. Parliament, doctrine of sovereignty of parliament means that the parliament is a supreme authority of the country. It can make any law it wishes. However, it can't pass an act which can never be cancelled. Court can't question validity of act. The doctrine of sovereignty of parliament says that the parliament of a country is the supreme authority. Supreme authority, superior authority. It can make any law it wishes. The parliament can create any law they want. However, they cannot make such a law, which can never be cancelled. Like for example, the parliament cannot say that we are going to make this law, and this law can never be cancelled into in the future. It does not work like that. Okay. Court can't question the validity of the act. Very important. The court cannot question the parliament, that why have you created this law. The court can't question validity of act. Okay, it's very important. This doctrine tells you that the parliament is the most superior authority of any country. Okay, so that's the doctrine of sovereignty of parliament. Clear? Now what
Yeah.
are the advantages of
So
legislation? And yes, yes.
you say it can't pass on act which can never be cancelled. So it means like the acts which pass from parliament, no one can cancel, right?
It means that the parliament cannot create any act, and and that act cannot be cancelled in the future. Like for example, a parliament creates a law, and they say that this law can never
Yeah.
be cancelled in the future. It does not work like that. They cannot create a law which can never be cancelled. Okay.
Okay.
Now, what are the advantages of legislation made by public representatives? Now, the parliamentarians, they are voted by the general public, right? So they are made by the public representative in a democratic country. So the people, they own the law, because the people will feel happy that, the person or the representative to whom we voted upon is there, and he is creating the law. So that's kind of an advantage. Made with high standard of care. We just saw that there is a proper detailed different stages which are involved in creating the law. So the standard of care is high, right? Proactive way of lawmaking. A legislation can be a proactive way. Like for example, if you can see that this issue can come upon, then you can create the law in advance, right? It's a proactive way. Instead of waiting for the issue, you can also create the law in advance. Like for example, if you feel that this issue can rise in the future, you can create the law right now. Okay. Disadvantage of legislation: slow and costly procedure. The problem with the legislation is that it is a very slow procedure. It takes time and costly procedure. A whole lot of administrative cost is incurred. So that's the disadvantage of legislation. MPs may not be technically competent. Another disadvantage, like, there are thousands of the laws that you need to create, like, right? For example, the law regarding the education are different, the law regarding the railways is different, the law regarding the medical field is different, the law regarding the accountancy field is different, right? So the
Yeah.
parliamentarians, they may not be technically competent to create any law, right? To create the law that is regarding to the specific field, right? They may not be technically competent. So that is a disadvantage of legislation. Okay.
Okay.
To overcome this disadvantage, we use another type of legislation that is known as delegated legislation. The parliamentary legislation, it is known as primary legislation. Delegated legislation is known as secondary legislation. Parliament delegates its legislative power to other bodies. They are transferring their some of the power to other bodies and asking them to create law. Okay. So in delegated legislation, the parliament will transfer their powers to some other bodies. And why will they do that? First reason is parliament may lack technical competency, that we just talk about. That the
Yeah.
parliamentarians may not be technically competent to create the law. So they delegate the power to somebody who is competent. Or the parliament faces time constraint. Like for example, there are thousands of the laws that are created. So the parliament do not have that much time to create all laws. So they delegate their power and they will only create the important laws. That's it, right? So the other laws can be created by the delegated bodies. Clear? Clear?
Yeah.
Now, what are delegated bodies? The first one is statutory instrument. Statutory instrument means the law made by the parliament, the law made by the law made by ministers. Like for example, you will say the railway minister, you will delegate your power to the railway minister and ask him to create the laws regarding the railways. You will delegate the power to the education minister and ask him to create the laws regarding the education. You will delegate the power to health minister and ask him to create the law regarding the health issues. Okay. So that is known as statutory instrument, that you are delegating your power to the ministers and you will ask them to create the laws in their relevant ministries. Clear?
Yeah.
Then you can delegate the powers to the professional bodies, technical bodies that can make the law related to their profession, like accountancy law, engineering law. Like for example, uh, you can delegate your power to the ACCA to create their own laws. You can delegate their power to the ACCA to create accounting laws. You can create a power to, the engineering association of a country to create engineering laws. So, you are delegating the powers to the professional bodies who are technically competent to create the laws regarding to their own profession. So you will delegate the power to them. Okay. Then local bodies. Bylaws are made by local bodies like municipal administration. Like for example, you will delegate the power, delegate the authority to local bodies of a country. Like for example, you will delegate the power to tehsil. I don't know. You know what municipal administration is? The city administration.
Yeah. Municipal
Okay.
council.
So you will delegate the power to the, let's say, mayor of the city, and you will ask him to create the laws relevant to the city. So you are delegating your power to the local bodies. And last is orders in council. Orders in council is basically privy council. There's a privy council that whose responsibility is to create the law in time of emergency in name of monarch on advice of PM. Now, what does this mean? Now, we just discussed about the parliament, how the law is created by the parliament. It is a time-taking process, right? But
Yeah.
sometimes a country need to make the law in emergency. So in time of emergency, there is a separate department in a parliament that is basically known as orders in council. So the parliament will delegate the bodies to orders in council, and they will create the law in time of emergency in the name of monarch on advice of prime minister of the country. So prime minister of the country will, if prime minister of country want to create an emergency law, then, on advice of Prime Minister, the orders in council will create a law in the name of monarch. The signature of the monarch will be there, and the law will be created. So, orders in council is basically works where you want to create the law in time of emergency. So you can delegate, the parliament can delegate their power to orders in council as well. Clear? Any question?
Okay. So you send me this lecture, right?
Yes, yes. Notes just after the class. So,
Yeah. Then I'll go through again, and if I have any problems, I'll ask.
oh yes, you can. No worries. Control over delegated legislation. You are delegating your authority, you are delegating your power to other bodies, so you must have a control over them as well, right? The first thing is, you don't delegate all of the powers but some of the powers, but still the authority or the power that you have delegated, you should have some type of control over that. Now, what are the types of the control? Controls are made over delegated bodies so that they cannot make laws which are against public interest. There are two types of control. So, to ensure that the laws are not created against the public interest, there are two types of the control that are implemented in the delegated legislation. Control by the court. I just told you one important point, that the parliament is the supreme authority, right? So the law
Yeah.
created by the parliament has a significance, but the law created by the delegated bodies, it has not a significance. Okay, only the law created by the parliament is supreme authority. So the primary legislation, it's important. The secondary legislation is not that much significance as compared to the primary one. Okay, have you got this point?
Yeah.
Okay. Now, how are the control procedures implemented? The first is control by the court. If delegated bodies exceed their authorities, you will see the word many times in upcoming chapters as well, ultra wires. The word ultra wire means that you are exceeding your authority. So if a delegated body is exceeding their authority and or making any unfair law, then court has a power to cancel that using judicial review. So if delegated body is creating a law by exceeding their authorities, or if they are making any unfair law, or they are making the law against the public interest, then the court has power to cancel that law using the judicial review. Okay.
Okay.
Now, if it was primary legislation, the court did not have any power, right? Court cannot even question the validity of act. Then the secondary type of control, second type of control is control by parliament. Parliament have scrutiny committees which reviews the law made by delegated bodies. So the parliament, they have scrutiny committees whose responsibility is to review the law that are made by the delegated bodies. Another committee of the parliament. Some statutory instrument must be laid down before parliament for 40 days before coming into the effect. Statutory instrument basically means the law created by the ministers. So some laws, that are created by the ministers, you must lay down those law before parliament for 40 days before coming into the effect. This is known as negative resolution. Negative resolution basically means that if a minister have created the law, then that law will be presented in the parliament for 40 days, and during those 40 days, if the parliament is not questioning that law, then this law will be created. Okay, this law will be approved and it will be validated. Okay, this is known as negative resolution. Clear?
Okay.
Some statutory instrument must need approval from the parliament. That is affirmative resolution. Affirmative resolution means that, when the law will be presented in front of the parliament, they have to approve that. That is affirmative resolution. Negative resolution means that if the law was presented in the front of parliamentarians, and they are not, it was just in front of them and they are not creating any issues regarding that in the 40 days, So, we will assume that this law is created because, they haven't questioned that in 40 days. That is negative resolution. Affirmative means that they have to approve that. They have to approve that, that yes, we have approved the law. This is affirmative resolution. Okay. Have you got the difference between the affirmative and negative one?
Yeah.
And then the scrutiny committee can review the delegated legislation, the law created by them. So these are three types of the control by the parliament. Clear?
Yeah.
Now, what is the advantages of delegated legislation and disadvantages of the delegated legislation? Advantages are it saves parliament time. The parliament time is saved, so the parliament can focus on the main issues, technical competencies. The delegated bodies, they have the technical expertise. So if they have technical expertise, then they can create a right law, right? Because they have the technical expertise. Quick process. Delegated legislation is a quick process. Hundreds and thousands of the laws can be created quickly with the help of the delegated legislation. What are the disadvantages? Criticized as being undemocratic. Now, because the parliamentarians are not creating the law, delegated bodies are creating the law, and the people have not voted the delegated bodies, right? So they can criticize those laws as being undemocratic. And the second disadvantage is volume and lack of publicity can be a problem because there are multiple thousands of the laws that are created. Now, how to publicize the law? So how can you, present those laws in front of the public? That is a real issue. Like for example, if you are creating laws regarding the city, you need to make the people aware about that, right? You need to advertise
Yeah.
those laws. Similarly, if you are creating the laws regarding, let's say, accountancy, you have to advertise the people. And advertising the people, it's not an easy task because there are thousands of the laws that are created, and you must ensure that in some form, these are accessible to the general public. So that can be a problem with the delegated legislation as well. So now the next topic is statutory interpretation. Statute basically means law. Statute basically means law. Interpretation means explaining the law. Now, the process by which judge assign meaning to the unclear word in the statute is known as statutory interpretation. Now, the law is created by the parliament, right? And the implemented and decision is made by who? Judge. Now the problem is that sometimes it is difficult for judge to interpret the law. Why? Because there are some unclear words, some ambiguous words that a judge cannot understand. The judge cannot understand those. So judge needs some type of assistance in understanding those things. So this is known as statutory interpretation. Okay. Like for example, I just give you a common example. Like for example, if there's a certain board in a place and in that board it is written fine for parking. Now what does this mean, fine for parking? What does this mean, fine for parking?
So if I park there, I have to pay fine.
It's a one thing, and fine means okay, you can do that, fine, it's fine, you can do that.
Ah, fine.
There are two things, right? It can be
Yeah.
penalty as well, and it can
Yeah.
be assurance that okay, you can do that. Now that's the problem, how to assign the meaning.
Yeah.
So in the law as well, there are some terms it is difficult for judge to assign the meaning to those terms. So the judge faces
Yeah.
difficulty in how to explain the law. So that is why the judge takes the assistance from the different sources. So this is what we are going to study in the statutory interpretation. Now what are the different sources that judge take assistance from? The sources are rules. There are certain rules that a judge can use to understand the situation, understand the law. Presumptions, there are some assumptions that judge can use while making the decisions, and there are some other aids, some other help as well. Now let's first understand the rules. Okay, so there are different rules. Judges use some rules for interpretation that are. So there are some different rules that a judge can use. The first rule is literal rule. Literal rule is words must be given their ordinary dictionary meaning, even if there is undesirable outcome. If in the law, there is a certain word that a judge cannot understand, he will just open the dictionary and he will see what is the meaning of that word. He will assign that meaning to the word, and whatever the outcomes come, whatever the understanding of the law come, the judge will follow that. That is known as literal rule. Okay. In literal rule, just the words which are not understandable by the judge will open the dictionary, and he will see that this is the meaning of the word, and he will use that word as the he will use that meaning to consider the law, to explain the law. Even if there is an undesirable outcome, even if the result is not desirable, still he will follow the literal rule. Okay. He will follow the ordinary dictionary meaning. Clear? This point is clear.
Yeah.
Now, there's a case in the book. There's a real case in 1961, and the law stated that it is crime to offer for sale offensive weapons. This is what law said, that it is crime to offer for sale offensive weapons, that you cannot sell the offensive weapons. But the wordings of the law were, it is crime to offer for sale. Now, there was a person, a shopkeeper, he put up a flick knife on a shop windows display. A person put up a, what flick knife is, right?
Yeah.
The small knife that you can flick. So a
Yeah.
person, he
Yeah.
put up flick knife, and the flick knife is an offensive weapon, right? So
Yeah.
he was brought forward to the court. Now the problem for the judge was to assign the meaning of the word offer for sale. What does the word offer for sale means? Now the judge was trying to understand the meaning. Now the word, what do you think, what does the word offer for sale means?
This for like
If I say that, I offer for sale, what does the word offer for sale means?
it is for sale, like
Yes, you are offering for sale, right? Now
yeah.
understand this point clearly. Now when the shopkeeper, when the shopkeeper was taken to the court, and when the judge said that, the claimant basically said that, that this person had put up the flick knife on the shop windows display, and it is a crime to offer for sale such weapons. The shopkeeper said that, I was not offering for sale that flick knife. Shopkeeper said that, I was not offering for sale. I have just put that in shop windows display. There was nowhere mentioned that, I was offering that for sale. He said that, the customer who wants that, he will come to me inside the shop and will say that, I want this weapon, right? He is the one who is offering for sale.
Yeah.
He is the one who is making offer for sale. The shopkeeper said that, that I just put up the flick knife. What is the, I did not, I haven't mentioned that, it was for sale. I had just put that in the shop windows display. It was the customer who had come inside, and and then he will make an offer to me. He will make an offer to me. So I was not offering for sale this offensive weapon. Have you got my point or not?
Yeah. Yeah.
Okay.
So it's like basically it's not mentioned that it's for sale or something like
Yes.
that, right? Just like
Yeah, it,
showing.
it just it was on the shop windows display, and the plus, he said that, the person who wants, he will come to me and he will make an offer for sale, that, I want this. I was not making
Yeah.
offer for sale. So
Okay.
that person, even if his intention was to sell the offensive weapon, he was still safe. Why? Because of the literal rule. So,
Yeah.
the law itself has a loopholes. So those loopholes can be targeted to save yourself. Clear?
Yeah. Clear.
Next is golden rule. Now, when you will go to the dictionary, there are multiple meanings of the word, right? Now, in the
Yeah.
golden rule says that when literal rule gives more than one meaning, give preference to that does make sense. Code can change, add words. The golden rule says that if, let's say, if one word has different meanings, then you will take that meaning that is making sense. In literal rule, because the word had only one meaning, so even if it was not making sense, you would have considered that meaning, right? But in
Yeah.
golden rule, if there are multiple meaning of the one word, you will give preference to that one that is making the sense. Now let's understand this with a case. Now there was a case in 1964, and now what was the law? Law says, law says that it is a crime to obstruct police officer in vicinity of prohibited place. It is a crime to obstruct police officer in vicinity of prohibited place. Now the thing is, there was a certain person who obstruct the police officer in a red zone area. You know what red zone area is? In which a general public is not allowed. Like for example, Parliament.
Yeah.
Like for example, in the UK, the King's Palace. Not all general public is allowed. So there was a certain
Yeah.
person who obstruct the police officer in a prohibited place. Now the problem was, the law said that it is crime to obstruct police officer in vicinity. Do you know what the word in vicinity in vicinity means?
The,
It
I
means
can't. I know
near
the word
nearby.
nearby
Like for example, if I
in the
say,
visibility or something.
yes, if for example, let's say that fight is not allowed in vicinity of school. That fight is not allowed nearby the school. Now the problem is,
Near the school, yeah.
does the school itself comes in the in vicinity term? Does school, the let's say for example, if the fight is in the school, does vicinity, thus you will consider school itself in vicinity? Now that's the problem. Now the word itself
No,
was saying that
yeah,
nearby, not that place itself, right?
nearby.
So again, this
Yeah,
is what the other person, the person who had obstructed the police officer in prohibited place, he said that in vicinity means nearby, not that place. In vicinity means nearby, not that place itself. But because this time the
yeah,
golden rule was used by the judge, so judge had to give the preference to that meaning, which is making sense. So the judge said that the purpose was to that police officer should do his duty, and no one should obstruct him within or nearby such type of the places. you know so that is why you could not obstruct the police officer. So the person who did obstruct the police officer, he did committed the crime. So he was basically charged with whatever the penalty was. Okay, have you got this point?
yeah.
So this is golden rule. Any question you want to ask, you can ask.
No, I'm clear.
Mischief, it depends upon the judge whatever rules he want to use. Okay, it's not that the one judge should use this rule or this rule. It's upon him.
It's option, right?
Yes, it's optional. Now the next rule is mischief rule. Now very important. Mischief means problem. Mischief rule says words are not problem. In the golden rule and literal rule, we were focusing on the words and their meanings, right? But mischief rule says
Yeah,
words are not an issue. Look at the mischief or the problem that statue was intending to resolve. Just look at the reason, just look at the problem which was to be resolved with the help of the law. Look at that. Do not consider the words. Look at the problem that law was trying to resolve. That was mischief rule. Now there was a case in which now the law states that it is crime to drive carriage while you are intoxicated. It is crime to drive carriage. Now carriage is basically any vehicle in which you can load the in which you can load the different luggages, right? Different things, you can load the different things. That is carriage. So the law said that it is crime to drive the carriages while you are intoxicated. Intoxicated means you are under the influence of alcohol. Now there was a person who was intoxicated and he was riding on the road while on bicycle. Now does the bicycle comes in the category of the carriage? No, right? It does not come, right? Bicycle is not a carriage, right? Carriage are basically vehicles in which you can load the luggages, right?
yeah,
But here we are not considering the words. We are considering the mischief. The problem that the law was trying to resolve was that nobody could drive on the road while intoxicated because he can harm others, right?
yeah,
A person on a bicycle who is under the influence of alcohol can also damage others, right? He can also be the cause of accident, right?
yeah.
So that person who was intoxicated, he was then charged with the penalty or imprisonment. Okay, so this is the mischief rule. Any question you want to ask?
Okay.
Then comes the purposive rule. Purposive rule is like kind of a broader approach to a mischief rule. Purposive rule says meaning should be derived by looking at the context. Context means parliament intention of the using words. what were the intentions of the parliament when they were creating the law. You have to look for that, and then you should assign meaning. Okay, so that is purposive rule. So purposive rule kinds of match with the mischief rule, but it is a broader approach. In purposive rule, we gave the meaning to the law by looking at what the context was, what was parliament trying to achieve by using those words. Okay, this is purposive rule. Now there was a law which state that X-ray films need to be stored on safe premises. There was a law that states that X-ray films, the case is of like 1950. Now the X-ray films, they are dangerous. They are dangerous because they can catch fire quickly, and that's why they are dangerous. So the law states that any X-ray films you need to store that in safe premises. Now a certain person stored that X-ray films in cave. Now, the problem was for the judge to decide whether the cave is a safe premises or not. So, what do you think? Is a cave
So,
considered safe premise?
um,
You know what cave is, right?
yeah, but people can go in.
Well, people can go, right? The thing is, the safe premises word is basically any premises which is covered from all four sides and it is safe, right? That is safe
Yeah,
premises where nobody can have access, right? Now, the
yeah,
cave, it is not a safe premises because a person can enter a cave, right?
okay,
It is
yeah,
not surrounded by all sides, right? By the wall from all sides. Now, that is
yeah,
what the judge said. The purpose of law was to provide for the safe storage of the film, wherever it might be stored, right? But the premises, the premises should be safe one. Okay. So in purposive rule, you are looking at what the purpose of the law was. So that was purposive rule. Any question you want to ask?
yeah,
Usedom generis. General words mean same kind of things as specific word they follow. Usedom generis rule says that the general words they means the same kind of the things as specific word they follow. Like for example, I will explain to you with an example. There's a case in the book as well in 1899. The law says that betting is not allowed in house, office, room, or other place. Okay, betting is not allowed in house, office, room, or other place. Now, a certain person did the best betting in the race course. You know what race course is, right? Where the horses race is done. Okay.
yeah,
Now, the
yeah,
problem was that whether the race course comes under the other place or not. Whether the other place,
it's one, yeah,
can you consider race course as other place or not? So, what do you think?
yeah, it's another place.
Now, what does the Usedom Genesis rule says? General words means same kind of the things as specific word they follow. So the other place is a general word and it will mean the same kind of the thing as previous words are indicating. House, office, room. Now,
Yeah,
very important point I am going to make. Now, house, office, and room, they are all indoor places. House,
India,
office, rooms are all indoor places. So the other place also means all types of indoor places. So the betting was done in an outdoor place, race course park, right? So despite that
yeah,
person who did the betting, he was saved. Why? Because according to the Euston Genesis, the other place meant the indoor places only.
okay.
Got
So
this point?
overall betting is not prohibited.
Yes, the law stated that betting is
Just
not
state
allowed
like,
in this,
yeah,
right? So
yeah,
the
yeah,
he
exactly.
used the law, the loophole in the law was used by that person, and that person, despite doing betting, was saved.
Yeah,
Then is expressio unius exclusio alterius. When a statute seeks to establish a list of what is covered by its provision, then anything not included in the list is considered excluded. When there's a law, when a law is trying to, establish the list of things covered by its provision, then anything not included in that list is considered excluded. Now, what does this mean? Let's understand this with an example. Like, for example, you go to a cinema, and outside the cinema, it is written, it is not allowed to bring popcorn, sandwiches, burgers, Pepsis inside cinema. So it means that if in the law these things are specifically listed down, then anything not included in this list is considered excluded. Like for example, if I go to the cinema and let's say I take pizza inside, so is the pizza mentioned in the list? No. So I will consider that the pizza is excluded, so I can take the pizza in the cinema. Got the point?
Yeah.
In a law, if you are trying to establish a list of the things that you want to exclude, then anything that is not that you want to include, that you cannot bring these things in a certain place, then anything not mentioned in that list is considered excluded. So that is why when you go to the cinema, it is written that no food or drinks allowed, right? So in food or drinks, everything's come under that, right? Food, drinks, everything. But if you are trying to make a list of the things that you should not take inside, then anything that is not included in that list is considered excluded. Okay. Then the next rule is nocitor is sources. It is presumed that the words draw meaning from other words around them. Like for example, if in the law it is mentioned that children books, children toys, and clothes, so we will assume that the clothes are also of the children. Okay, not clothes of everyone. So this is nocitor assois. Children books, children toys, and clothes. So the cloth also will mean the children clothes. So we will, the other words around the word, we will draw meaning from them. Got that? Clear?
Yeah.
In perimeteria, two laws relating to the same subject matter or sharing common purpose must be considered together. It simply means that, like for example, if there's a divorce case, so you can instead of taking one law, you can consider two law in making the decision. In helping, the judge can consider two laws regarding the same matter to help himself, in making the decision. That is known as in peri materia. That you can take two laws regarding the same subject, two or more laws, okay, which have common purposes, and consider them together in while making the decision. That's in peri materia. If it is a marriage law, you can consider two or three different marriage law while making a decision. If those laws are regarding the same subject matter, that is in peri materia. Clear?
Yeah.
Then comes the presumptions. Presumption basically means we will assume, the judge will assume these things while making the decision. These are assumptions that applies unless the law state otherwise. Unless the law is against these assumptions, this is what the judge is going to always assume. The first, a statute doesn't bind crown. A law does not bind the king or the queen of the UK. The law is not applicable on him. A statute cannot conflict with international law. A law cannot conflict with the international law. Okay. A statute doesn't alter common law. A statute cannot change the common law. Common law will be there. The statute will have obviously preference over the case law, right? Legislation has preference over the case law. Equity has preference over the common law. Legislation has preference over the equity, or you can say case law. But a statute does not change the common law itself. Okay, it will stay there. A statute doesn't have retrospective effect. A statute doesn't have past effect. Like for example, there was a law that is created that that if someone will, let's say, do drugs, he will be imprisoned for, let's say, 1 month. Previously it was 6 months, but now it's 1 month. Now this 1 month will be applicable from the future. The past decisions that are already made, they are made. This law will not have any past effect. Okay, it will only have prospective effect. Okay. A statute generally has effect in UK, because we are talking about the UK law. The statute has effect in UK. A statute doesn't exclude jurisdiction of the court. A statute cannot exclude the authority of the court. Okay, a statute doesn't exclude the authority of the court. So these are the presumption. Presumption means this is what judge will always assume while making the decision, unless the law state otherwise. And the last aid is the other aids. There are other kind of help. One is intrinsic aid and the second one is extrinsic aid. Intrinsic aid means inside book of the law. Like for example, when the law is created, it is like kind of a small booklet. So anything that is inside that booklet, it is known as intrinsic aid. And anything that is outside the booklet, the general magazines, these are considered as extrinsic aid. Now what are intrinsic aid? Title of the law, objective of the law, preface, appendix, side notes. So all these things are in the booklet of the law. So if the judge are taking help from that booklet, then this is known as intrinsic aid. You just need to remember these things. That's it. Okay. You don't need to go into detail. While extrinsic aid means outside book of the law. Like for example, law commission reports, judge can take help from that. Hansard Hansard is a record of parliament discussion. When the parliamentarians are having discussion regarding an issue, those discussions are recorded, and those are presented, or those are summarized in an Hansard. So judge can take help from Hansard as well. Judge can take help from old cases as well. Judge can take help from help from international law as well. Okay, we are talking about statute interpretation. So these are other types of help that a judge can take. Clear? Any question you want to ask, you can ask. The last topic is Human Rights Act. Human Rights Act HRA 1998 covers all the issue regarding the human rights, some of which are right of life, right of freedom, right of education, right of expressing religion, right of free speech, right of privacy, right to fair trial. So there are many other human rights. So Human Rights Act 1998, it covers all the issue regarding the human rights matter. HRA 1998 binds all public authorities not to breach an individual rights. All public authorities are bounded by the HRA 1998. They have to follow the Human Rights Act. UK citizens can settle their claims for violation of the human rights in local courts. If there is a violation of human rights, UK citizen can settle their claims in the local courts as well. Now, the Human Rights Act is of very, very significance. The UK considered the human rights, as a very significant matter. So that is why they have some implications. They have some impact on the legislation. Now, what are the impacts of HRA on legislation? Please read. Okay. Now, what is the first point? All new statutes must be made according to the HRA clauses. Any new law that you are going to create, that a parliament is going to create, they have to create that according to the Human Rights Act clauses. It means it should not conflict with the Human Rights Act. All existing legislation must be modified according to the Human Rights Act. The existing laws, they must be modified according to the Human Rights Act. Courts must consider HRA clauses while making its decision. The courts must consider the Human Rights Act clauses, the things that are presented in human rights, while they are making the decision. Any judicial precedent which is against HRA will be considered invalid. If the previous judge decision was conflicting the Human Rights Act, it will be considered as invalid. So it has very significance. If existing statute is in clash with HRA, let's say for example there's an existing law and it is clashing with an Human Rights Act clause, then the court will issue incompatibility order. When the court will see that a current law is in conflict with the HRA, Human Rights Act clause, then court will issue incompatibility order, and the parliament will review the law. Parliament will review the law. If parliament denies to change it, the law will still be valid. We just talk about the sovereignty of the parliament, right? Parliament can make any law they want. So even if the court has issued incompatibility order regarding any existing statute and parliament are not willing to change that statute, then that law will still be valid even with the incompatibility order. So this is the significance of Human Rights Act in the legislation of the UK.